On June 12, 2018, Keith Raniere and Allison Mack were in court for a bail hearing for Keith Raniere. Bail was denied, but the full transcript for the trial is available on artvoice.com, and I'll put a link below. But if you don't have time to sit and read through it all, I am going to go through some of the highlights here in this video. So the defense for Raniere said to the judge that they would like him released on a $10 million bond, and they said that he would be secured by a minimum of 2 armed guards, security professionals, and they would have the former director of the U.S. Secret Service who was sitting in the second row in court, who would be working with the security guards. The judge replied, "I'm really curious about this concept that someone would be on house arrest, basically guarded by people with guns. What's the purpose of having armed guards? Is the purpose of having armed guards in the case that the individual being guarded tries to flee? They have authority to stop him and possibly use their guns, shoot and kill. In other words, to shoot and kill somebody, which sounds absurd to me, frankly, on its face. Or is it to stop people from coming in, like reporters or people who feel wronged by Raniere, and to protect him by shooting the intruders? What's the purpose of the armed guard?" And the defense lawyer said that he understands that someone can consent to physical force being used against them, but not deadly force. And so the judge said, so then you need a couple of karate experts, and that instead of people with a gun. And the court laughed at that. And then the defense said it's a matter of integrity, reputation, that the security guards would not want, or Mr. Sullivan would not want anything to go in the wrong direction. So he said the guns are just the icing on the cake, and what really keeps him there are the guards. And he goes on to say there's a trust, a defense trust that has been created since the inception of the case. It's being administered by a trustee. The trustee has a lawyer and no defense costs. And he said, I say this because the renting of the apartment for Raniere and paying of the armed guards would be a defense cost which would not be paid unless it were ordered by Your Honor. So the guard, just to be clear, the guards and the apartment would be paid from this irrevocable trust that's been created. But right now there's no apartment because there's no bail condition authorizing the expenditure of money on the apartment. So the judge said, so I'm like a co-trustee if I agree to this. And so the condition precedent of the expenditure funds, the court agrees to something of this nature. And the defense attorney said, well, they can't spend anything unless it's a reasonable defense cost, and so they need it to be ordered by the court. And the judge said, well, I'm not aware of the trustee's name. I'm not aware of who the settlers are for the trust. I'm not aware of the funds that are in the trust. But put that all aside, this is not your client's money. And they said that's correct. And the judge goes on, the purpose of having individuals act in the capacity is that they place some moral suasion on the defendant to adhere to the terms of release. But there is no one to do that in this case, the way it's been structured. And the defense agreed. So he said, so someone can write a check for a large sum of money, take millions of dollars just out of thin air, put it in an irrevocable trust, and that trust could be used for the purposes that you have outlined, but there's no moral suasion placed upon the defendant to adhere to the terms of the bail, because frankly, he has nothing to lose. Only people who have something to lose are the settlers of the trust and perhaps the trustee for some fiduciary behavior, but if that should happen, but there's nothing that really keeps the defendant in tow. In effect, he has no family members who are going to sign the bond. It's just him. So the question becomes, assuming we go forward with something like this, how does, apart from the fact that there is money available, how does this guarantee that your client doesn't get on an airplane at Teterboro Airport without any kind of travel documentation and fly in a private plane to a place where he gets off the plane and nobody knows where he is? Or if the flight plan is changed mid-flight, which happens, and he's gone and nobody knows where he is. So the defense tried to argue that the security guards would not let that happen, that it would be their reputation at stake, and that they would be the ones to make sure he showed up in court. He said the defense said the guard's job is to make sure Mr. Raniere is safe, secure, and he comes back to court each and every time. So, but that still doesn't make up for the lack of moral suasion. And he recognized that he admits that it was an unorthodox way to structure a bond package, but they thought it was very effective. They said he won't have a passport, and he can't apply for a passport, and he'd be on a GPS monitor, etc. The judge said, what about the situation with him going down to, Puerto Vallarta, Mexico, and staying in a gated community, operating an email account with the protection that he couldn't be, he couldn't have his email checked. And why? What would you do if you're the defense said that because there are two, what I've seen, well-entrenched, passionate factions having nothing to do with law enforcement that surround Mr. Raniere, there are people in NXIVM and DOS, some of whom are very loyal to Mr. Raniere, and then there are people who have left NXIVM and or DOS who are, from what I've seen, equally passionate anti-folks. I don't tend to reference the press in court matters, but I think it's interesting to note that I think New York Magazine piece, the journalist noted they're taking photographs of her and others at different points in time. Here they're talking about the Bronfman sisters, the ones who created the irrevocable trust. So then the defense said that the reason, more pointedly, and I know the government was concerned about his trip to Mexico, was that the mother of his child's visa was about to expire. So they traveled to Mexico. When they traveled to Mexico, that's why he was there, basically. And the judge said, they were not in Puerto Vallarta. They were living 5 hours away somewhere. So he's in one place, Raniere's in one place, and his mother of his child and his child were 5 hours away from him. He said, and the state said, Your Honor, at the time of the defendant's apprehension in Mexico, the mother of his child, I believe, was in Monterrey, while the defendants were in Puerto Vallarta with DOS slaves. And the judge said, with who? And the state said, with DOS slaves, including co-defendant Miss Mack. And the judge said, oh, you called them DOS slaves. I see. All right. So the judge is just getting learning the lingo here for this case. Look. Judge said, so look, I understand that your presentation, very extensive, clear presentation. I'm concerned about the fact what could happen is that you've got these law enforcement people who retired, who are in his organization, and has people mad at him and everyone at risk because he's at risk. And if these people come after him, then you've got people protecting him with guns, and this is not your ordinary bail application. So the defense said that they don't think there would be any violence. They don't think that anyone would be coming after Raniere. They don't have any reason to believe anyone would get violent. They're only concerned about hacking, computer hacking. And he said that the defense said that Raniere, if he were released on bail, he would not have access to the internet. So they said. But the judge said, we're concerned about the fact that we don't know where this money is coming from, and the fact that the people who have private jets can fly people wherever they want, fly them, and they don't necessarily have travel documents in order to do that. And we don't know whether, in effect, we're setting up a private jail here. Does the court have to start taking into account the fact that when the court may be sanctioning is in effect a private jail with all the accoutrements of a mansion, perhaps? People with a great deal of money can set up a private jail with all kinds of amenities. Then it sort of makes a mockery of the system of justice, while other people can't get $100 together to get out of Rikers Island. I think it's a really big problem, not just a social problem, it's a criminal justice problem, and I don't know that I want to contribute to it unless I know who is providing the money and how much we're talking about. I'm concerned on flights. I think if we get past the issue of flight, we can move on to some other issues. Then the state said, Your Honor, the government absolutely believes the private jail concept has inherent problems, but in this case in particular is a case where clearly it is not the right outcome. The only cases where this type of private jail has been allowed, which does have enormous policy implications, have been cases of white-collar criminal cases where the defendants themselves were putting up enormous sums of their own money. In this situation, Your Honor, the defense counsel has given his best guess as to who is financing his trust. But then she went on to say, that the defense has indicated that they know who's funding the trust. Everyone knows, the Bronfman sisters, the Seagram heiresses. But they didn't want to say it in court. But they read it in the New York Times article, and the judge referenced the New York Times article. And so the state says, okay, Your Honor, based on that guess, this is a person who the government believes has acted as a co-conspirator in criminal activity with the defendant Raniere. Okay, so part of the reason the defense didn't want to bring up the Bronfman sisters by name is because the government is looking to indict them. That's a known fact. Well, they haven't done it yet. And then the state goes on to say he has acted as a co-conspirator of the co-defendant for many years, and given that in addition to the fact that over the years they've given him large amounts of money. She said on one occasion, Bronfman sisters provided Raniere with a $65 million loan, and which he lost on the commodities market, and it was never repaid. So this is the type of amounts of money, it's really unimaginable wealth and limitless wealth that we're talking about here. So the idea that any amount of money would not be worth it to this person to allow the defendant to flee, should we end up in that situation, is unimaginable. She said that the person, and the Bronfman sisters, is equally capable, along with the defendant, of trying to live off the grid. They're talking about people with private islands, talking about people with access to private air travel, which the defendant has participated in, people who have been using encrypted email, people who have been dropping their phones so that the government is unable to track them. So this is an environment we're operating in, and I do believe that the risk of flight is significant in this case, and they believe that unlike many cases in which private jails have been proposed, this is a case where there's a real danger to witnesses, to victims, if the defendant is released. This is somebody who has a network operating around the world that literally one text message can mobilize hundreds of people who could do his bidding. And so that, with all due respect to Mr. Sullivan, there is nothing that Mr. Sullivan is going to be able to do on a day-in, day-out basis to prevent something like that from happening. Your Honor, the people are truly petrified of the defendant. This is an organization that has operated for years by manipulating people, by abusing people, and by intimidating them. Okay. Because there have been, over the years, the Bronfman sisters have filed multiple lawsuits against former NXIVM members. And this isn't in the court. I'm saying this as an aside. They're not But this is what she's referring to, is that the Brofman sisters and Raniere with this cult, NXIVM, they've used the legal system and abused the legal system in attacking people and going after anyone who criticizes them. And they've gone after his ex-wife, for example, who, he raped her and he was brutal to her, and she ended up divorcing him. And then because she spoke out against him publicly, they filed lawsuits with the Brofman sisters' money against the ex-wife, and they bankrupted her. And even when she applied for bankruptcy, they sent a lawyer in to oppose her bankruptcy. I mean, they were really, just constantly attacking people legally with their money and with the legal system. So this is definitely not your average defendant when you're talking about someone with this kind of money. So then, then the judge asked, anything else before I rule? And the defense said, yes, so we have spoken about this, and Your Honor's right. Your Honor's suspicion of who is funding the trust, whether there's 100% or 99%, it's exactly what it is. And the judge responded, my suspicion is not a suspicion. I'm just saying that in the ordinary course, sureties come before the court and explain what their relationship is with the defendant and attempt to give the court some assurance as to the surety of what they're doing so voluntarily, that they have a relationship, that they will do everything they can to oversee the defendant's behavior to the extent that the defendant will return to court and provide that sort of assurance, a group of assurances, so the court can feel that there is a strong likelihood that the person will not abscond, among other things. The defense said that he understood. And then the judge said, but then there is this other issue that's raised obliquely by the government, that this supposed financial backer of this irrevocable trust may be either an unindicted co-conspirator or subsequently an indicted co-conspirator with the defendant. Where are we then? That complicates the analysis substantially, it would seem to me. And so the judge ended it with the defendant, Keith Raniere, has been charged with sex trafficking, conspiracy to commit sex trafficking, and conspiracy to cause another to engage in forced labor. The defendant has moved to release on bail pending trial. The court finds the government has shown that the defendant is a flight risk, notwithstanding the proposed conditions. The court therefore denies the defendant's motion without prejudice.